Imagine this. You dedicate your entire life to a dangerous, demanding job, counting on certain protections for when you retire. But then you find out those protections might just disappear the second you walk out the door for the last time. Well, that's not a hypothetical. That's the exact situation that took a retired firefighter all the way to the Supreme Court, and it forced the justices to answer a really fundamental question. When you retire with a disability, does the law that protects you retire with you?
So let's meet the person at the very heart of this story, Karyn Stanley. Back in 1999, she joined the Sanford, Florida Fire Department. She had a plan: serve for 25 years. And a huge part of that plan was the city's promise of health insurance until she turned 65. But, just a few years in, the city completely changed the rules. Now, let's fast forward to 2016. While she's still an active firefighter, she gets a life-changing diagnosis: Parkinson's disease. And just 2 years after that, she's forced to retire early.
And under that new policy, that health coverage that was supposed to last until age 65? Nope. It was now capped at just 24 months, 2 years. For someone whose career was cut short by a disability, this wasn't just some small change in the fine print. This was a catastrophic loss of the security she had earned over almost 20 years of service. And this, right here, is what kicked off a major legal battle.
So you might be wondering, how does this deeply personal crisis for one firefighter spiral up into a huge test case for one of America's most important civil rights laws? Well, it all boiled down to one incredibly powerful piece of legislation, the Americans with Disabilities Act. The entire, and I mean entire case really hinged on the definition of just 2 words in the Americans with Disabilities Act, or ADA: qualified individual. The law is clear. It says the ADA protects a qualified individual from discrimination. But what on earth does that actually mean? Well, the law itself says it's someone who can do the job they hold or desire.
And that one phrase brings us right to the heart of the conflict. Stanley's side argued, look, the protection she earned when she was a qualified employee shouldn't just evaporate the moment she retires. Those benefits were part of her compensation package. But the city of Sanford had a much different, much stricter interpretation. They said once she retired, she no longer held or desired a job. So in their view, she was no longer a qualified individual, and because of that, she was no longer protected by this part of the ADA.
So, when this case finally landed at the Supreme Court, everything boiled down to this one central question. Is a retiree, someone like Karyn Stanley, still considered a qualified individual in the eyes of the law?
Okay, so the court's majority, they zeroed in on something you might find surprising: grammar. Yep, you heard me right. Grammar. As you can see in this quote from Justice Gorsuch, who wrote the majority opinion, he pointed directly to the words Congress chose to use, words like holds, desires. He said, hey, these are present tense verbs. That's a huge signal that the law was written to protect people who are currently working or currently looking for a job.
The majority built its entire argument on what's called a textualist reading of the law. Basically, that means they're focused strictly on the literal words on the page, not the potential spirit of the law. They pointed out that other parts of the ADA talk about things like job restructuring or banning employment tests. Those things, they argued, just don't make any sense for someone who's already retired. So they came to a stark conclusion. The law is designed to protect people, the qualified individuals, not to protect their benefits in a vacuum after they've left the job.
So when you put all that together, the majority came down with a very clear, very narrow ruling. They decided that the ADA's protections against employment discrimination apply at the very moment the discrimination happens. And at that exact moment, they said you have to be a current employee or a job applicant to be protected.
But that was not the end of the story. There was a really powerful dissenting opinion from Justice Ketanji Brown Jackson, and she offered a completely different way of looking at this. She argued that these benefits are a core part of the job itself, and they can't be doled out in a discriminatory fashion no matter when that check is actually cut.
And this slide really breaks down the dissent's logic because it's so clear. Step 1, while you're working, you're a qualified individual. Makes sense. Step 2, while you're that qualified individual, you earn retirement benefits. She saw these not as a future gift, but as deferred compensation. It's like part of your paycheck. You just get it later. So step 3, discriminating against those benefits, even years later, is still discriminating against the qualified person who earned them in the first place.
Justice Jackson's dissent basically warned that this strict grammar-focused reading of the law creates a giant, completely illogical loophole. It would mean an employer could promise all sorts of benefits to an employee with a disability, wait for the day after they retire, and then just snatch those benefits away without any consequences under the ADA. This, she argued, just completely guts the entire purpose of the law.
Okay, so after all of that legal back and forth, you're probably asking the most important question. Where does this leave us?
Does this ruling really mean that retirees with disabilities are just out of luck with no ADA protection for their benefits? Well, it turns out the answer is a little more complicated than a simple yes or no.
You see, the court's majority opinion actually left a door open. The absolute key is when the discrimination happened. Let's think about the different moments. If the discriminatory act is the denial of benefits after you've already retired, the court says no, you're not protected. But, and this is crucial, the majority suggested a claim could work if it's tied to a moment when the person was still employed. For Karyn Stanley, that would have been that window between her diagnosis in 2016 and her retirement in 2018. During that period, she was a qualified employee with a disability who is actively subject to what she argued was a discriminatory policy.
So what's the big takeaway here for retirees? Well, while Karyn Stanley herself ultimately lost her case, and that was mostly because of some procedural issues in how her case was argued, the Supreme Court basically left a roadmap for the future. The timing of the claim is everything. They strongly hinted that a future retiree could win a similar case, but they'd have to prove the discriminatory injury happened while they were still on the job as a qualified individual, not after they'd already cleaned out their locker.
So in the end, this case gives us a much clearer picture of what the text of the law says, but it absolutely does not resolve the tension at the very heart of this issue. It leaves us with this huge, lingering question about the real purpose of the Americans with Disabilities Act. Is it a law that's only for current workers in the workplace, or is it a much broader promise of dignity and equality that should follow people into the retirement that they rightfully earned?